This video is going to talk about the Constitution, and specifically the Constitutional Convention, and how it sets up a government that is going to fix some of the problems of the Articles of Confederation, and also answer the question, how do we guard against tyranny? First of all, the Constitutional Convention was held in May of 1787 in Philadelphia, and the delegates that attended from every state except Rhode Island were there simply to fix the Articles of Confederation. When they went there, that was their sole purpose, not to throw it out and start a whole new entire constitution and form of government, but they quickly realized that some of the problems of the Articles were just too difficult to fix, and so they needed to start from scratch. And a few of the most influential figures in the founding era were not there, including Thomas Jefferson, who was serving as the ambassador to France at the time. A little bit about the delegates was that most of them were wealthy lawyers, people who had served in Congress before or been officers or been state governors, and the average age was 42. So they didn't always represent the poorer individuals of society, but they certainly were more well-to-do than many others. One of the essential questions that they had when they sat down to write the Constitution was, how do we guard against tyranny? Because that had been one of the driving forces behind the Articles of Confederation, and why they made it so weak is that they were concerned that if the federal government got too much power, that the states would then be overwhelmed by it. And so the idea was that we need to allow the federal government to have power, but not too much power. And the ways they're going to do this is federalism, separation of powers, and checks and balances. Federalism is the idea that there are certain powers that the state has, certain powers the national government has, and some that they share. So in this instance, one of the national powers, for example, is to declare war. Another one is to establish money system. Because you can imagine if we allowed states to declare war on other countries, how challenging that would be. Just as the same with states, one of the things they can do is set up schools. Another thing is they can deal with commerce or trade within just their state. Some of the things that are shared powers is collecting taxes. For example, most states, people pay state income tax as well as federal income tax. There are certainly some exceptions of states like Texas that they don't collect state income tax, but they have other taxes to make up for the money. The second one is separation of powers, and this is the idea that you have three branches of government. And under the Articles of Confederation, they only had a legislative branch, and it was just one house even within that. And so there was no executive branch and no judicial branch to solve some of the disputes that were going on. So they realized that they were going to need these three different branches of government in order to ensure that none of them becomes too powerful. The legislative branch's job is to write the laws. And so they're the ones that are responsible for creating every bit of law legislation that you see. The president's job, or the executive branch, is simply they can propose laws to be passed by Congress, but really they're the enforcers of the laws, and they make sure that laws are carried out. And the judicial branch is the one that determines whether or not the laws are actually constitutional, whether or not the Congress has that power. And as you can see by this graphic, you also see there's some additional things that each branch has, including legislative branch having the power to declare war, not the president. But as we'll see in future years as we discuss throughout U.S. history, that more and more the executive branch takes some of that power and gives the ability for the president to send troops into battle as they are the commander-in-chief of the armed forces, but without the Congress actually having to declare war. And a little fun fact, we actually haven't declared war as a nation since we declared war during World War II. So all of these other wars supposedly we've had are considered to be simply actions that have been taken by the military. One of the other things was checks and balances. They didn't want any branch to become too powerful. So, for example, there are certain things that the president is allowed to do to ensure that Congress doesn't get too powerful. For example, if Congress were to pass a law that the president didn't agree with, he would have the power to veto, which would nullify the vote, unless Congress had the power to have 2/3 of its membership override it. Another thing is that the president has the power to appoint judges. They also have the power to make pardons, so if the court, for example, is going to put someone in jail, the president has the ability to say, well, I think that's wrong. Also, the judicial branch has the power to declare laws unconstitutional of Congress, The Congress approves the federal judges. The president has the ability to appoint someone to the Supreme Court, for example, but Congress has the ultimate say in whether or not that person actually gets to serve on the bench. As we saw with the administration of President Obama, he did put someone up, Merrick Garland, for the Supreme Court, but Congress refused to have hearings or vote or any kind. And once President Trump was in office and chose Neil Gorsuch, then Congress did approve that. So the president is only so powerful, the Congress is only so powerful, and the courts are only so powerful. Here's another example of some of the other things that different branches can do to check the power of the other branches. And the idea is that they would all be 3 co-equal branches, with none of them becoming too powerful. At the Constitutional Convention, you had all kinds of different issues that came up, and there was really a question of whether or not this fine experiment in democracy was going to work. And so we have 4 compromises that were made, the most important of which is the Great Compromise, that helps us to understand how fragile this new government was. So the first problem was that question of representation. And the small state of New Jersey proposed that everybody be equal. So they wanted one house that had equal representation. So every single state would have the exact same representation regardless of how many people. Well, Virginia, being a big state, didn't like this. And they thought that representation should be based on the population of the states, therefore having larger states having more say. So what the compromise is, also known as the Connecticut Compromise, is that you have 2 house legislature, with the upper house or the Senate having equal representation. So every state, regardless of the population, has 2 senators. The lower house, or the House of Representatives, was based on population, and every state gets at least 1 representative, but then states like California have 53 representatives because we have such a larger state. Obviously, we didn't exist back then, but you get the idea. The second question then became, well, if we're going to have the House of Representatives based on population, then do slaves get to count? And the southern states said no. They should be allowed to count in representation. However, we don't want them taxed. And the northern states said, well, we don't think they should count in population because you don't actually count them as people. So why should you get the benefit of having extra people when it comes to representation? However, we're happy to have those slaves count for taxation. So the 3/5 compromise says that 3 out of every 5 slaves would count in both population and for tax purposes. The next compromise also is between the southern and the northern states, and in this case, the southern states wanted state control of regulation of all trade. They were opposed to a federal ban on the slave trade, and they didn't like the idea of a federal duty or tax on agricultural exports, because that was really where their livelihood came from, was different imports, as we've talked about cash crops before, exports, sorry. The northern states, however, did want the federal government to regulate all trade, and they wanted the government to be able to collect duties and tariffs, again, a type of taxes. So the trade compromise became that the federal government would regulate interstate, which means between the states, so between Florida and Georgia, for example, and the international trade between other countries, whereas the states would have regulation over their own states' trade. There would be no export duties to be passed for 20 years and no ban on the slave trade for 20 years. So this is one of the 2 areas in which they even discussed slaves. The other was the 3/5 compromise, and now here. But these are the only 2 mentions of slavery at all in the Constitution, because it was a really controversial discussion, and they were afraid that if they even brought it up, that many of the states would just walk away. And the final compromise is between people that supported states' rights and people that supported a stronger federal government. So states' rights supporters wanted the state legislatures to actually determine who would be the president. This means that the people that were in the local government on the state level would get to choose. They wanted the president to have a short term, and they also wanted there to be a limit on the number of terms that the president could serve, because they wanted a lot of the power to remain in the hands of the state governments. The federal power supporters wanted the direct election of the president by qualified voters. And we know at the time that qualified really meant those that owned property, white men who owned property. They also wanted the president to serve a longer term, and they didn't really want any limits on the term. So the compromise was that there would be an indirect election of presidents through the Electoral College, which allows people are able to vote for who their electors will be, but then in the Electoral College, in theory, those individuals are more educated and would be able to make a decision separate from the will of the voters. The term of service would be 4 years, and there would be no limit on the number of terms. Well, in 1951, they changed this with a limit to 2 terms by the 22nd Amendment, following FDR's election to 4 different terms. The Supremacy Clause establishes that the federal Constitution, and by that means federal law, is going to take precedent over state laws and even state constitutions. So in theory, a state government cannot pass a law that violates the federal government's law, and that always you go to the higher law. The Commerce Clause allows the government to regulate trade with foreign countries, also allows them to regulate trade between the states. It's used along with what's called the Elastic Clause to expand federal authority over time. That deals with navigation, it deals with even modern civil rights law. And there's a landmark court case in 1824, which we'll come back to in period 4, Gibbons versus Ogden, that deals with the issue of the Commerce Clause. The Necessary and Proper Clause is that Congress has the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by the Constitution. Basically, what this means is that Congress has the ability to make additional laws that are not listed specifically in the Constitution, but might be necessary in order to execute their existing powers. So this is the idea of giving flexibility to the Constitution. And when we talk about Hamilton versus Jefferson, we will come back and talk more about this idea of flexible versus not flexible Constitution. And the final thing is implied powers, that there are certain people that will believe that what is written in the Constitution are the only powers that the government should have. However, this idea of implied powers says not every power that you have is written expressly in the Constitution, and that those that are delegated powers means they are written out. For example, Congress has the power to declare war, is listed. That's a delegated power. But sometimes there's additional things, such as when we get to the 20th century, we have the question of airlines and TV and radio. Do we need to regulate them? Are laws actually passed by the government to restrict some of the things that they're able to do? That is not listed in the Constitution because there were no airlines or TV or radio in 1787, but it's a power that has become an implied power and used through that necessary, proper, or, as I mentioned, elastic clause. And that is it on the Constitution. Thank you.